Well, welcome everybody. My name is Sarah Sackman. I'm a barrister here at Francis Taylor Building. You're very, very welcome to this afternoon's rating law seminar. I'm one of a team of practitioners here at FTB that, amongst other specialisms within local government and public law, we do a lot of rating and have worked with a great many number of you. I can see we've got, it may not feel like a cast of thousands, but we have got over 330 people I can see joining us, and we really do welcome you warmly, and we look forward to the time when we can be filling halls and pressing the flesh and doing all of that. This afternoon we've got a stellar lineup of speakers: Cain Ormondroyd, Horation, Mark Westmoreland Smith, and Gregory Jones, who I'll introduce shortly. It's obviously been a very busy time for rating practitioners. We heard yesterday from the Chancellor of the Exchequer that business rates relief is being extended until June. Our high streets, our pubs, our restaurants, or our hotels and other small businesses, particularly non-essential retailers, have been under huge pressure, and no doubt yesterday's announcement will have come as something of a relief, even more so if one is in Scotland, where the relief has been extended even further. But clearly it's a challenging time, and that throws up challenges in our area of practice. It's not necessarily going to be the focus of all our presentations today, but clearly the effects of the pandemic, the prospect of lifting lockdown, but what that will look like is something that I think necessarily influences and will be informing the sort of work we'll be doing for some time now. And I know we'll be hearing from Greg, who has some experience of what this means within the City of London. But there's lots to talk about. So without further ado, I'm going to introduce Cain. Before I do that, I should say something about how we're going to structure this afternoon's seminar. We're going to hear from all four of our speakers to begin with, and they've got their presentations to share with you. And then we're going to have some time for Q&A at the end. But I know what it's like, and having done rating seminars with many of you before, I know there'll be lots of burning questions. And so we want you to share those with us as we go. We've got, as you can see in the toolbar at the bottom, a question and answer function. And so we'd ask that if you've got comments, thoughts, thought-provoking questions, usually fiendishly difficult, try not to make them too difficult, please. Have mercy on us all. Please put them in the Q&A function rather than the chat, because actually that makes it easier for our team to answer as many of them as we can as we go along. And then we'll have time to have a bit more of a discussion towards the latter part of our seminar this afternoon. So please, we want to make this as interactive as possible. So please, your thoughts and questions in the Q&A box. And one more thing I should add, poor Cain is hanging on with bated breath, is that all four of our speakers have produced PowerPoint presentations. They'll be shared on the screen, and we are very happy to share those with you after the event, so you don't have to feel the need to scroll everything down, and you can enjoy the presentations. Right, well, let me hand over first of all to Cain Ormondroyd, who I know will be known to a great many of you. He is a Band 1 go-to junior, real specialist in this area. He's been in many of the leading cases over the last few years. He's an editor of Ride On Rating. He's an editor of, well, not editor, he's the writer, author of his own pocketbook, which I know is indispensable, not least because it fits in one's pocket as opposed to Ride. And Cain is going to be talking to us about the costs of fit out. Over to you, Cain.
Well, thank you very much, Sarah, for that kind introduction. Let me try and accomplish the first technological leap that's required here by sharing my screen, and hopefully everyone can now see the slides. Is that visible to the other speakers? Yes, so hopefully to the audience. So thank you, Sarah, for the kind introduction. I'm going to talk today about an issue which, although it's been with us for some time, seems to have become far more controversial in the 2017 list. And it sits on the borderline of law, fact, and valuation judgment, which is so productive of argument in the rating world. And the question is, broadly put, how to deal in a rental valuation with the cost of what are called fit-out works. Perhaps a more accurate term would be tenant's works, or works done by the tenant, because the tenant may, of course, do works above and beyond simply fitting out the hereditament for the purposes of occupation. And having just corrected my own terminology there, as an aside, the terminology in this area can be a vexed issue. You have, shell and core, category A fit out, category B fit out, and so on and so forth. And I was once appearing in front of a surveyor member of the upper tribunal, who interrupted proceedings at one point to say, "Is anyone going to tell me what category A actually means?" And he was greeted, as I remember it, by a rather deafening silence from the lawyers and the surveyors in the room. So we would all have a general idea of what category A means, a sort of basic level of fit out, whereas category B is your sort of full fit out with furniture and everything ready for occupation. But there was no specific definition of what category A means, none that anyone could point him to at that time. Anyway, I'm sure one of the 400 or so attendees at this seminar is now going to post one in the Q&A. But I'm going to avoid those terms because they can shed more confusion than enlightenment, and look at the issue more broadly. What I hope to do is to really state the problem and how it arises, identify the questions that arise for valuers, and some answers that have been given historically, touch briefly on some recent cases that I've been involved in touching on this issue, and end by suggesting, if not a solution, at least a structure for the questions which come up. So the problem, there we go, the problem. The problem arises, as so often, from the collision between the rating hypothesis and the real world. The rating hypothesis requires valuation of the actual hereditament rebus sic stantibus, with things as they stand, or perhaps I should say in accordance with the reality principle. And one of the things that has to be taken as it stands is, of course, the hereditament itself in its finished condition. Now, the real world may not supply any direct rental evidence about the value of that hereditament. And that will be the case if, for example, the tenant has done work to the hereditament since it was let. The problem will be compounded if it's commonplace in that market for tenants to do works to hereditaments after they have been let. The rent for that hereditament and for any comparable hereditaments may therefore have been agreed in respect of something other than the hereditament as it stands. And so that leaves a gap between what the rating hypothesis requires one to value and the available evidence from the real world. Now, the problem, it is a gap. It's not a complete absence of evidence. It's not a situation where the lack of evidence is such as to drive the valuer into an R&E or contractor's basis valuation. But there may well be plentiful rental evidence in general on hereditaments of that sort, offices, department stores, whatever. But nevertheless, there remains a gap which has to be, and the question is as to how that gap is to be bridged. Fundamentally, I think there are two questions which arise for valuers. The first question and fundamental question is whether the tenant's works add value to the hereditament at all. The quotation I've put on this slide from the Lands Tribunal emphasises that is a question which has to be addressed. If the works don't add value, then the gap I referred to is more theoretical than real, and one can simply take the rental evidence and apply it in the rating valuation. And that will be very much the case if the tenant's works don't actually change the hereditament at all. So, for example, putting in furniture, things which don't then form part of the hereditament to be valued, those works or that expenditure will not have any effect on the value of the hereditament, because it's the hereditament being valued. Similarly, the tenant's works wouldn't add value if they made the if they made the hereditament worse. But assuming that the tenant isn't completely incompetent, normally works will only be done, money will only be spent if the works are somehow fitting the hereditament more closely for the tenant's purposes. So why would such works not add value? One might wonder, why does this question have to be asked at all? Well, it may be that the works are done to future-proof the hereditament against some change of use which the tenant has in mind to make at some point in the future. As the hereditament has to be valued as things stand, then any value attributable to a possible change of use in the future has to be left out of account. So that would be one fairly clear example. A more common but potentially more contentious example will be works to personalize the hereditament, to make it specifically fit the requirements of the tenant involved. And this can take in anything from a personalized layout of partitioning, and provision of kitchen facilities, or whether it's open plan or small partitioned areas in an office, through to sort of branding and decoration. And the thing about these works is that at the same time as making the hereditament more suitable for the actual tenant, they also make it less suitable for other potential tenants, potentially, who may have very different requirements. But balancing that consideration is the fact that the actual tenant is one of the hypothetical tenants. It is in the pool of demand represented by the hypothetical tenant in terms of the rating valuation. So interesting questions come up as to at what point works such as that, works of personalization, pass the threshold beyond which they're not adding value to the hereditament vacant and to let anymore. And those are conceptually difficult to resolve satisfactorily, and may, depending on the amount of the works, be of little value significance. So they are, in my experience, generally either fudged or compromised. Anyhow, talk of fudge and compromise leads neatly on to my second question, which is how much value do works add? And again, there is likely to be little market evidence on this. One is very unlikely to have the luxury of seeing lettings of two equivalent hereditaments, one fitted out and another not yet fitted out, so as to be able to make a direct comparison. There are various indirect methods which are used, therefore, which each has more or less of an evidential basis, and probably less. The first two I've listed on the slide in particular rest really on convention and general acceptance of them. One will be to make a percentage addition to the rent in the lease for the tenant's works, and that percentage will vary to reflect the age and quality of those works at the time of evaluation. Another will be to adjust the rent by deeming that part of any rent-free period it has been given by way of allowance for fitting out or tenant's works, and thus the adjusted rent is higher than it otherwise would have been. So that part of the rent-free period is not treated as an incentive, which brings down the headline rent. And again, the extent of the rent-free period which is accounted for in this way will be varied depending on the extent of the works. the consensual application of those sorts of methods has served us well for many years, by preventing really us from having to grapple with the fundamental issues which underlie this area, and the fundamental lack of evidence really to get an answer to those questions. However, rating is becoming increasingly litigious. I don't know why that is. I'm certainly not going to complain about it in my line of work, but I have sensed that there has been a lot more controversy about this whole issue in the 2017 list, and that forces valuers to grapple with why they're making these adjustments and on what evidential basis. The alternative to the broad brush conventional adjustments is to conduct a contractor's basis valuation of part of the hereditament. And that has generally been used in the past and for specific features or specific enhancements to the hereditament. The two examples I've cited were both about air conditioning systems. Theoretically, I suppose one could value the whole of the works of the tenant's works on the contractor's basis. Theoretically, one could do that. But the important thing with this method is if the contractor's basis is being used, then the statutory decapitalisation rate must be applied to change the capital cost of the works into an annual figure that can be added to the rent. And that has implications because that figure is fixed at a certain level. And so one side or the other may therefore be attracted to the use of that because it offers, through the costs which can be quantified and that statutory decap rate, which is fixed, a more exact answer and a apparently more accurate answer. But I think we shouldn't necessarily confuse exactness and accuracy for correctness, and the accuracy may be spurious. But that is one method that has been used. And it may be that people seek to apply that more to tenants' works more broadly as litigation in this field develops. So I mentioned that this has got more controversial recently, and I'll just touch on two cases in the 2017 list that I've been involved in where this has come up. The first was a case which involved the VO making retrospective additions to the rents to justify the list valuations, which turned out to be higher than could be supported by the rents alone. And this was a case where the works reflected the tenant's preferences. They were done to hereditaments which were already lettable, already usable, I should say, by a tenant. But there was a forceful argument from the VO that they added value to the tenant and that rating sought the value of the occupation to the occupier. That argument was pursued on the basis that this case was a test case, but the VO's argument failed at the VTE, and then their appeal to the upper tribunal was withdrawn. So although it was gratifying for me to have won effectively without a shot having been fired, it's frustrating in that we haven't had guidance from the upper tribunal on this. Although watch this space, there may be a rerun. There may be a rerun before too long. Second case to touch on is Devlin Stalls, and this one's ongoing, so I'll be careful about what I say. But here, effectively, the argument about tenants' works was one cog in a larger valuation dispute about department stores. And the VO approached the costs of the tenants' very large fitting out works by taking the costs of those into account when adjusting the rent and effectively setting them off against the landlord's capital contribution. So they took it into account in adjusting the rent. The ratepayer comes back and says, oh, you're doing a contractor's basis valuation, therefore you have to use the statutory decap rate, and these rents, this all works out very differently to what you have said. So it's large, it's given the number of Debenham stores, potentially high value enough to go some way up the tribunal system. So watch this space, there may be some interesting guidance emerging. final slide, as I've said, really organises the questions I've posed to you in a structure and a format that hopefully you can work through if you have a case raising these issues. Thank you very much for listening, and I'll see there have been some questions. I'll try and come back to those in the Q&A later. Thank you.
Thanks very much for that, Cain. I'm speaking for myself and having advised on a couple of cases which deal with this issue. It is a difficult one to grapple with, and as you say, I think we're all waiting for that test case which provides that guidance. So it'd be interesting to see if your Debenhams case goes somewhere. Thank you for that. Then we turn now to our next speaker, Horatio Waller, who's going to be talking to us about setting aside liability orders. I know that Horatio, who is one of our brightest and best juniors here at FTB, has a growing practice in rating law and has lots of practical experience about just how you do this, setting aside liability orders. So he's going to talk to us about that and some of the practical issues that arise. Horatio.
Thank you, Sarah. I'll just share my screen. Hello, everyone. Thank you for listening to my talk today, which is going to be about setting aside liability orders. So what are liability orders? You probably know this better than I do. They're enforceable judgments from the magistrate's court. They're made against either ratepayers or council taxpayers where they fail to pay the rates or the council tax that's demanded. Now, to save time, I'm going to refer to ratepayers and council taxpayers as the taxpayer, because the process for set aside is very similar in both cases. What the law says is that liability orders can be set aside upon an application made by the taxpayer in specified and quite limited circumstances. What I'm going to cover today is a very brief recap on the process of applying for a liability order, a very quick recap on the conditions that are set out in the law on setting aside a liability order, and then touch on two recent examples that demonstrate the complexity that applies where you have insolvency proceedings that are also underway on the basis of the liability orders that haven't been paid, and the complexity that arises in that context where the taxpayer is both attempting to set aside the liability order and also to annul or rescind their bankruptcy. And if set aside orders weren't complicated enough in experience, and they certainly can be in my experience, they are additionally complicated in the insolvency process. And I know this because I was involved in one of those two cases. So in terms of the recap, very briefly, the magistrate's jurisdiction to make a liability order arises where the process, the very prescriptive process, set out in the applicable regulations is satisfied. So you've got the 1989 regulations that deal with rating, and you've got the 92 regs that deal with council tax. And it's a similar process, and typically it involves a demand notice, and then if that's not paid, a final reminder. If that's not paid, the billing authority issue proceedings in the magistrate's court upon a complaint. The court issues a summons, and the summons directs the taxpayer to appear at the court on a specified date. Now, the way things should work is the taxpayer should receive the summons, and then they have the opportunity to attend court, and if they wish, and they can, contest the liability order. Set aside isn't the only way you can contest and challenge a liability order. Like any judgment, there is an opportunity to appeal. It's what's called an appeal by way of case stated, where you're dealing with the magistrates. There's also the right to apply for judicial review. And so in a context where the taxpayer did appear at the magistrate's court, contest the liability order, and they were unsuccessful and the order was granted, probably the appropriate method of taking the challenge further will be one of those two methods, an appeal or judicial review. But what frequently happens is that the taxpayer claims that they weren't aware of the final hearing, and so they didn't turn up to the final hearing, or they might claim that they weren't even aware of the proceedings at all, and so that's why they didn't attend. And in those circumstances, what the law allows the taxpayer to do is to apply to set aside the order. This is a procedure that's developed very much on a case-by-case, drip-drip basis under the law. It's not subject to the civil procedure rules, including the time limits as to when you need to launch your proceedings. So case-dated appeal and judicial review, there are very strict time limits. The time limits isn't set in terms of a specific number of days when it comes to a set-aside application, albeit you need to apply promptly. In set-asides, you can provide new evidence showing that you're not liable for the rates or the council tax, and the procedure is intended to be informal and inexpensive. Briefly, these are the three conditions that are now established following the Hamden case as to the conditions that need to be satisfied. All of them need to be satisfied before the court will set aside your liability order. First, that there's a genuine and arguable dispute as to liability. So you don't need to show that you're not liable, but you need to meet a sort of minimum threshold that there's a dispute. So for example, you're not the rateable occupier if it's rates. Second, the order was made as a result of a substantial procedural error, defect or mishap. And most frequently in my experience, the argument that's raised is that the summons wasn't properly served, or perhaps it was properly served, but it wasn't actually received because the taxpayer had moved house, or they were out of the country, or something of that sort. And thirdly, the application must be made promptly after the taxpayer learns of the order, or they have proper notice that the order's been made. So those are the conditions. I could say a lot about those conditions, elaborating on them and the case law that's developed on them, but I'm not going to do that. I'm going to launch into a very practical discussion of what happens where you also have insolvency proceedings. So by way of context, if a liability order has been granted by the magistrates under the regulations, that is deemed to be a debt upon which the billing authority can attempt to make an individual bankrupt or a company wound up. And two recent cases in the High Court, one that I was involved in, concerned situations where the taxpayer disputed the tax and they maintained that they only became aware of the liability order proceedings and the bankruptcy proceedings after they became bankrupt. So they were not only attempting to set aside the liability orders, but they're also attempting to set aside the bankruptcy. It's important to note by way of context that in a similar way as the liability order process, in order to obtain a bankruptcy order, there is a prescriptive set of requirements that need to be followed. And that includes, in particular, serving a statutory demand, demanding the payment of the relevant sum, and then a proper application for a petition for bankruptcy or winding up. But if the process is followed and no one turns up to the bankruptcy court to contest the order, then just like in the magistrates, the bankruptcy court will grant it. So that the first case is the case of Yang. In a nutshell, you have here a property that's designated as an HMO under the relevant council tax rules. On that basis, the demands are sent to the owner of the property. Those demands are not settled. Liability orders are applied for. The liability orders are not contested. There's no response to that. And the orders are obtained. The billing authority serves a statutory demand for payment of those orders. That's not responded to. The sum isn't paid. And so they petition for bankruptcy, and that petition is not responded to. No one turns up to the bankruptcy court, and so the order is entered. So all of this has happened without the individual seemingly responding to any of these processes or attempting to dispute any of this. What then happens is, in 2011, the taxpayer then says, she discovers all of this. This is some 5 years after the original demands in question were served. So 5 years of process has been followed. And at that stage, she then makes the argument that, in fact, she's not liable for any of this tax because the original decision to designate the property as an HMO was flawed. And eventually she succeeds in that argument. What she did immediately, which was in hindsight a very sensible thing to do, was she paid the liability orders. And she did that so that then that would essentially reserve her position, make sure that the bankruptcy situation didn't get any worse, and she would pay it then and then attempt to get the money refunded in due course. So she made a proposal to the VOA, and then subsequently that was decided on appeal at the tribunal, that the rooms should be separately listed, and that was eventually accepted by the tribunal. The billing authority did the proper thing, which was to refund the council tax that had been paid. But where did that leave the taxpayer in respect of the bankruptcy order? So what she did was she applied under the Insolvency Act to either annul or, if that was rejected, rescind her bankruptcy. And the outcome, eventually confirmed by the Court of Appeal, was that the bankruptcy should be rescinded, but shouldn't be annulled. Now, this was quite an important point of difference because rescission terminates the bankruptcy going forward, whereas annulment is essentially casting it aside and treating the bankruptcy as never having been made. And it can make a big difference in terms of wiping your record clean. And that means, for example, that this taxpayer will now have on their credit rating that they were made bankrupt, which in hindsight was something that perhaps could cause her injustice. The argument was that the order should have been annulled because the liability order and the bankruptcy order ought not to have been made. But the courts disagreed with that. Lady Justice Gloucester gave the leading judgment, the Court of Appeal, and her ladyship said this, that the liability order is deemed to be a debt under the regulations. And so that's a ground for petitioning for bankruptcy. At the bankruptcy court, the court doesn't have the jurisdiction to look behind the liability orders, except in the event of some miscarriage of justice. And there was no suggestion here that there was any miscarriage of justice. If the bankruptcy court hears the taxpayer and the taxpayer say, I contest my liability, then what the court should do is they should adjourn the bankruptcy proceedings to give the ratepayer taxpayer time to set aside the liability order. But that didn't happen here, because in this case, at least according to the taxpayer, she didn't know about the bankruptcy proceedings. And in her case, even though the liability order was effectively set aside, it wasn't formally set aside because she paid the money and then it was refunded. But even though it was effectively set aside, the court rejected the argument that the bankruptcy should be annulled. Lambert. This concerned lots of demands for rates and council tax for lots of properties, several liability orders. The bankruptcy petition is made and the individual is made bankrupt. And this individual maintained that they only became aware of the bankruptcy and the orders several years after the first demand was issued. They applied to set aside the liability orders, but eventually that application was refused. And then after that, they applied to annul their bankruptcy. The first attempt that they made to annul the bankruptcy failed because there was a breach of court directions. And in the second application, a High Court judge dismissed the application in part because the court accepted that it couldn't look behind the liability orders until they're set aside. And so after this, the taxpayer had another go at trying to set aside the orders. And I'll need to say this quickly because I'm running over time. Eventually, the outcome of that second application was that the court held it was res judicata because the taxpayer had already had one go at set aside, and you can't have another go because the matter's already been adjudicated. In addition, the court held that where someone has been made bankrupt, they don't have standing to apply to set aside liability orders unless you can get the consent of the trustee in bankruptcy. And so that was another problem that this individual faced. So moving forward, a bit of guidance to assist you if you deal with similar situations. The bankruptcy court can't look behind the liability orders. You have to apply to set aside in the magistrate's court, or if you can, appeal or judicial review. You only have one opportunity to set aside the liability orders unless there are serious fraud or collusion allegations. If there's a petition for bankruptcy, you've got to resist that and then ask for more time to set aside the orders. And if you've already been made bankrupt, then the magistrates can refuse your set aside application on the basis you don't have standing. And so you need to go to the trustee in bankruptcy and get their permission to do this. So I hope that guidance is helpful for you if you deal with these quite complicated situations going forward. Thank you very much, everyone.
Thank you very, very much, Horatio. That was impeccably timed. Very, very good. Thank you so much. And now moving swiftly on to Gregory Jones QC. Greg has a very wide-ranging practice, I should know, because many hundred years ago I was supervised by Greg as his pupil. My favourite directory entry describing Greg has to be when he was described as not just a meat and two veg silk. I don't think he'll ever quite live that down. I'm not quite sure what else you are if you're not a meat and two veg. But
Greg, low fat, healthy eating.
Yeah, exactly. We don't like our silks, diet style at FTB. We like them with, bringing real substance to the table. And in that regard, as I said, Greg has a wide-ranging practice in planning, local government, compensation, and because of his experience in local government directly through the City of London as well, direct experience of what SMEs are facing at the coalface at the moment in respect of business rates. And Greg's going to speak to us now about the fallout of Woolway and Mazars and where we are now. Over to you, Greg.
Thank you. I'm just press share screen, and hopefully you can confirm whether my my PowerPoint come up. Sorry, what's happened? Hello?
Greg, hello. I'm not sure we can see it just as yet.
I've just done share screen.
I'm not seeing it, but maybe all
Share.
members are. Oh, hang on. This looks good. This looks good. There we are. Perfect.
There it is.
Brilliant.
Is
Thanks.
that it? Good.
Great.
Okay. Well, I'll forgive Sarah your reference to hundreds of years ago. You're sounding like my daughters now, who talk about dinosaur ages when we refer to the 1990s or 2000s. So we're not quite looking back there, but this is just really partly mainly a recap, and then just to talk about a decision dealing with the implications of the repeal of the so-called staircase tax and the time limits and how those are applied in order to get a re-evaluation post the Woolway decision. So the first thing to note, of course, is that although the Woolway and Mazars decision of the Supreme Court was referred to as an introduction of a staircase tax, it isn't, of course, a tax on the provision of staircases. It's not like the 18th century window tax. So what I'm just going to recap on is, firstly, the Woolway and Mazars decision. What was it about? What did it decide? And then the government's response with the rating property in common occupation and council tax brackets empty dwellings Act 2018, trips off the tongue. I'm not going to talk about the empty dwellings element of it because that was not a response of Woolway, but that, of course, is obviously very interesting of itself. And I think it's a very good illustration when we go through it of perhaps what's wrong with the rating system and why we need a proper overhaul of the system. And I'm not saying anything there that I suspect is not shared by many of us here today and expressed elsewhere. So what happened, just to remind ourselves, of course, in rating, it's always very personal that the valuation officer has his or her name in the case. But Mr. Woolway entered 2 floors occupied by Mazars in an office block. There were floors 2 and 6 as 2 separate hereditaments on the ratings list, and Mazars disputed the decision, and very quickly Mazars succeeded before the valuation tribunal, which concluded that the 2 floors should have been considered as one unit for the purpose of the ratings link as a result of the essential functional link, as the floors were occupied by the same tenant in the same office block. We're looking at the situation where you've got an office block, you're renting the 2 offices, others rent, no doubt, offices above and below you, and the staircase is communal, and you walk across the staircase to get to your other office. A very common example. Mr. Woolway appealed to the upper tribunal, arguing that the floors were not adjoining, there was no contiguity, and again the upper tribunal dismissed valuation officer's appeal, applying the well-established Gilbert and Higginbottom authority from the 1950s, and ruling that a common sense approach should be applied to the notion of contiguity, so that you can be contiguous even though you're not physically joined together. But they said that was applying a common sense approach. The 2 floors, when you looked at them, as a matter of common sense, there was, yes, a staircase in between, but they were sufficiently close together to be considered a single unit. And again, 3rd time, Mr. Woolway tried, 3rd time unlucky. The Court of Appeal concluded that the geographical physical proximity tests, which were set out in the Gilbert case, applied by the upper tribunal were again applied by the Court of Appeal. They should be applied flexibly, and the Court of Appeal drew attention to the fact that the floors were connected through communal parts of the building was evidence enough of a close enough geographical and physical connection. But fourth time lucky, in the Supreme Court allowed the appeal, holding Gilbert to be plainly an unsatisfactory decision. It's quite interesting, isn't it? That something that was plainly and therefore obviously an unsatisfactory decision had nonetheless stood the test of time for over half a century, and had not been really called into question by any of either the specialist tribunals hearing the matter or the Court of Appeal. Lord Sumption, who gave the lead judgment, amalgamated tests to be found in Scottish cases, and to come up with a three-staged approach comprised of three principles. There was geography, and functionality, and one of enjoyment, and you would apply each of those tests as a matter of fact and degree to see whether it's a single hereditament or not. And I put the various key quotations next to it. Now, the consequences of the Supreme Court judgment, as everyone probably knows, there's a lot of press at the time, was that property adjoining each other, but that did not directly intercommunicate with each other, would be treated as more than one hereditament. And you had examples that I've already given of staircases, and hence the press dubbed it the staircase tax, which of course it's not. The Valuation Office Agency began investigating 70,000 properties that comprised a single hereditament for business rates purposes. Many of them were split into more than one hereditament. For some with more than one floor in the same building, they saw their business rate significantly. And then, of course, it was rubbing salt into the wound. They were backdated to 2015. And I give an example there that was picked up in the press, an example of what that would do to business with an open market rental of less than 51,000. I set that out in the slide. I won't read it out. Also, there were other consequences as well, because some businesses that otherwise were eligible for small business rate relief then saw their property split into parts, may have lost their relief because they now had two or more rateable units. So you can see there was a succession of consequences. I've given a link to the Commons Library report that set out in some greater detail the consequences. Those House of Commons reports are usually very good, and this one's quite good. So if you're interested in looking at the consequences, I suggest clicking on the link. Government reaction. This was the previous Chancellor, Sajid Javid, remember him? He said, I've listened to businesses affected by the so-called staircase. We'll change the law to ensure that where a business has been impacted by the Supreme Court ruling, it can have its original bill reinstated if it chooses and backdated. What was the legislation intended to do? Well, the government has said in some of its extramural publications, and I've given you the link to the fact sheet, and this may be important if you have to come and argue the matter. The government's stated intention in any event is that not to make any reforms to the business system in this respect, simply to reinstate previous practice in accordance with government policy. So that was the intendment of the bill that then became the Act in 28, effectively reversing the staircase tax and to a larger point, Woolway and Mazars. So in summary, one rating assessment will now generally be applied to neighbouring floors or units occupied by the same business, providing they're contiguous, and they're not used for wholly different purposes. And there's some key takeaways. Premises are contiguous with each other if they show at least part of a common boundary, such as a wall or a fence. They're in consecutive floors, or at least part of the floor of one unit lies directly above at least part of the ceiling of another unit. Premises might still be contiguous, even when there's a space between that which is owned or occupied by another person, for example, the ceiling between two floors. And unusually for legislation, but for reasons that are understandable, but this is sort of an example of what is still relatively rare, retrospective legislation. Changes were to apply back to financial years beginning on or before the 1st of April 2010, and allowed the minister to make regulations that allowed ratepayers whose hereditaments have been split to apply to the valuation office agency to have the hereditaments treated together. Affected businesses were able to request a recalculation of any values made since that date. So the regulations were made. I'm not going to read them out. They're even longer than the Act, but you've got them there. And it's part 2 that is the applicable part. Others deal with nursery and other matters unrelated to my talk. Part 2 provides for a new ground of proposal to alter a valuation list where 2 or more hereditaments are shown to be 1 as a result of the amendments made by the Act. So where does that leave us? Well, on the face of it, as I've said, it's been made clear that the legislation was intended to put us back to where we were before, so that I suppose if there are any arguments, it depends on whether the courts or tribunals will be prepared to look at that extraneous material. And to some extent, already they are. And the decision I just want to end by referring you to is the Libra Textiles case, which is really to do with the regulations. Obviously, a number of businesses took advantage of the opportunity to reassess their rates liability, and one of them was Libra Textiles, and it made an appeal to merge the rating assessment of its Boundary Mill store at Cain in Lancashire with the assessment. And you may wonder why I got the fish and chips on. It's nothing to do with Sarah's introduction to me, and you may see that this is a homage to the great Kirsty McCall. People can put in what that reference is if you pick it up, but they wanted to merge the assessment of the fish and chip shop known as Bannies Limited on the site, and there was also another Centric Asset was making appeals to merge the assessment of industrial units forming part of a printing works in Portsmouth and Hampshire. So the rating assessments that the subject of the appeals made by these 2 companies had not actually been altered as a result of the Supreme Court's decision in Woolway, but the companies used the opportunity of the regulations, which they said could allow you to reopen the ratings list in order to take a punt and see if they could get a more favorable rating assessment. What then, the first issue for the determination then for the upper tribunal was whether, in fact, the fish and chip restaurant and the Boundary Mill stores property at Cain were actually in common rateable occupation, and whether they were properties that fell within the 2018 Act. And the tribunal found that whilst BMS, this is the Boundary Mill stores, could not do anything else in that part of the premises occupied by the fish and chip restaurant, quote, the fish and chip restaurant is an integral part of BMS's operations and the restaurant business is under tight control. So having made that finding and applying the another Supreme Court decision, the Cardtronics decision against Site, the upper tribunal found that both the shop and the restaurant had the same rateable occupation and fell within the ambit of the regulation. So the only question then in both cases was whether the appeals had been made out of time. So the appellant said, we're in time because of these regulations. And the valuation officer changed his tune. And at the hearing, put a different case to the case that was in the respondent's stated case. And for time purposes, I won't go into any detail what the valuation officer argued orally. He was arguing that properties were not only contiguous with one another, they were directly interconnecting and therefore one hereditament. But the tribunal didn't like that, didn't find that convincing or attractive, but instead preferred the valuation officer's actual case as stated in their stated case. Good example of perhaps it's wise not to change your mind, and basically said that that because the regulations had come into force to deal with the consequences of the Supreme Court case, and neither of these cases had been affected by it, that they were out with these regulations and therefore out of time to challenge the 2010 rating list. And the point I flagged up earlier, and I'll finish on this point, is that in considering not the purpose of necessarily the Act, but the purpose of the regulations as well, the tribunal looked at the explanatory memorandum attached to the Act, which strictly speaking isn't part of the Act, and concluded from the explanatory memorandum that only ratepayers who were affected by the change in law could reopen the 2010 list, and found that these poor old chip shop with Elvis in it, or not, as the case may be, was not in it. So it was held to be out of time. So I hope I'm not out of time, and I will finish there, Sarah.
Greg, that was terrific. And you won't have seen, but Ian and Tim, they both picked up on the Kirsty McCall reference.
Excellent.
So that was excellent. Thank you for that. Thank you so much. Well, we come now then to our fourth and final speaker of the afternoon, Mark Westmoreland Smith. Can I see Mark? There's Mark. Brilliant. I'm sure Mark will be known to a great many of you. Mark's on the Treasury Solicitors B panel. He deals in all sorts of matters relating to DCOs, local government, rating, planning, the lot, including in the rating field, most recently, the case of Ludgate House and the Court of Appeal, which he's going to tell us all about. Mark.
Thank you, Sarah. Good afternoon. I'm going to talk about, as Sarah said, the recent Court of Appeal decision in London Borough of Southwark and Ludgate House and Andrew Ricketts, who was the valuation officer. This case was the latest round in what's been a fairly long-running saga in relation to the effectiveness of a property guardian scheme as rates mitigation. And I've been acting for the VO throughout. Now, what I propose to do today is just run through briefly what guardian schemes are. I'm sure many of you will be familiar with them, the facts of the case, the findings at the various levels, and some conclusions. So what are guardian schemes? Well, when a non-domestic building becomes empty, the owner has a number of difficulties. Firstly, he derives no rent from the building, all the while incurring the costs of maintaining it. Secondly, he remains liable to pay rates. And whilst the current scheme for non-domestic rates affords owners of empty buildings some rates relief, that only lasts for a period of 3 months in the case of the majority of commercial buildings and 6 months for industrial buildings. Thirdly, the owner will need to incur some costs in terms of securing the premises against trespassers. And the enactment of Section 144 of the Legal Aid, Sentencing and Punishment of Offenders Act 2012 has made it an offence for squatters to enter and remain in occupation of residential properties. And so the effect of that legislation has been to push squatters to occupy commercial as opposed to residential premises, which has had a real effect on the ground. One solution to these problems has been the use of property guardianship schemes. So what are they? They typically involve the owner entering into an arrangement with a third party that contracts to provide for property guardians to enter into occupation of the premises. The contract between the owner and the third party will make clear that the guardians are entering into occupation for the purposes of assisting the owner to secure the premises against trespassers, and will usually expressly state that the third party is not being given exclusive possession of the premises. The third party then may perform some adaptations to the premises, such as providing showers, toilets and kitchens if they're not installed already. And the space in the premises is then let to individual guardians who will be required to live there as their home. And the attraction for the guardians is essentially, as I say on the slide, cheap rent and central locations. The rent tends to be well below market rate, and because they're commercial premises, they may well be in a central location. Guardians will usually occupy pursuant to a contractual license, and the license will make a number of stipulations that usually stipulate that the guardians need to reside there for a minimum number of days per week. They'll require them often to report or confront intruders, and they'll expressly state they don't have exclusive possession of any part of the relevant premises, and that they can be moved to about the premises at the landlord's will. The owners of the premises occupied by guardians will often be paid a portion of the rent paid by the guardians to the third party, but the real benefit to the owner is the potential rates occupation. Owners of the building occupied by guardians will seek to have their buildings deleted from the rating list on the basis that the guardians are in rateable occupation and not the owner, and that the guardians are occupying the premises as a residence. So with that sort of introduction to guardian schemes, let's just look at the facts in the Ludgate House case. This was a large office building, 11 floors, 175,000 square foot, just on the south bank of the Thames, between Blackfriars Road and Blackfriars Station. And Ludgate House Limited acquired the freehold in 2010 and subsequently applied for and got planning permission to demolish the building as part of a larger redevelopment. It had a tenant in there from 2010. That tenant left in March 2015, at which point possession reverted to Ludgate House. And Ludgate House at that stage entered a contract with VPS, who provide guardian services, to secure the building against trespassers, and they arranged to get 32 guardians into occupation. The contract between VPS and Ludgate House expressly provided that VPS was not being granted exclusive possession of any part of the building. The guardians, as usual, occupied pursuant to a license, and that license said they wouldn't have exclusive possession. They couldn't be away from the building any more than 2 nights in the week. They had to challenge unannounced visitors or trespassers. And after about 6 weeks, there were 46 guardians, but on the material day, only 4 guardians had moved into the building. They occupied individual rooms, which were effectively partitioned offices. And at that stage, no works had been carried out. and VPS carried out some works after that material day when the first guardians moved in by installing showers on a number of floors and some cookers in pre-existing office kitchen facilities. Then after the 6 weeks, there were 46 guardians. They all had their own rooms, but their occupation spilled out beyond the rooms, beyond the partitions offices, into the open plan office space. And on a couple of occasions, Ludgate House exercised its power to move guardians around the property. So it first went to the VTE, and the VTE decided in essence that whilst the guardians were physically present, their occupation was heavily restricted and under the control of and on behalf of Ludgate House. And so it was clear to the VTE that it was Ludgate House, not the guardians, that were in paramount occupation of the whole, and Ludgate House was a single hereditament. That conclusion was rejected by the upper tribunal on appeal by Ludgate House. The first key finding of the upper tribunal was that the guardians' rooms satisfied the Mazars' geographical test. Looking at the first 4 guardians' rooms, you could draw a line around the individual rooms. And the upper tribunal decided in the end it didn't matter that the occupation spilled out beyond this line, and I'll touch upon that in a minute. So with that finding, the tribunal went on to consider who was in rateable occupation and paramount control of the 4 separate putative hereditaments, the 4 rooms. And the upper tribunal held that the guardians were in actual occupation of the 4 individual rooms. And looking at the Lang's test, actual occupation, it held that they were not in occupation on behalf of Ludgate House. The upper tribunal said that the licensees were not in a contractual relationship with Ludgate House. They provided no service to it other than as a byproduct of their residence. And they couldn't be removed from the building except on notice. There was a 28-day notice period. As to occupation exclusive to the purpose of the possessor, the tribunal held, so far as the rooms were concerned, they were occupied by the guardians, and it was their purpose that was important. And their purpose was to provide themselves with somewhere to live, and that was exclusive to the guardians. And they further found that it was beneficial and not to transient occupation. It was worth just noting a couple of other issues that were before the tribunal but not determined as a result of their conclusions on the rateable occupation. The first of those was that if they had come to the alternative, which was that it was a composite hereditament, what was the proper approach to valuation of the non-domestic part of that hereditament? And it did provide some observations on what it might have concluded if that had been relevant. It said there was a disagreement over whether the building should be valued on the assumption that the licensees were scattered throughout the premises, the actual facts, or consolidated on 2 floors. The critical assumptions are that on the material day, the building is vacant and to let, and that the incoming tenant wishes to occupy it in a manner consistent with the mode or category of occupation existing in reality. And the tribunal said that the mode or category of occupation was that of an office building in temporary accommodation of residential licensees, pending the building being put to other uses. And that since that mode of occupation of the hereditament is fixed by reference to the facts as they were on the material day, the hypothetical tenant is stuck with the residential licensees in the same locations as they existed. That was the argument that was put by Ludgate House. But the upper tribunal said, we think that approach pays too little heed to the assumption that the building is vacant and to let. and too much deference to the manner in which the actual occupier managed its own business. So that its inclination was that if such a building is to be assumed to be of interest to a new tenant willing to pay an office rent, but for whom some reason wanted to accommodate the guardians, the incomer would maximise the use of the right to allocate space in the manner most convenient to it. So that reflected the arguments that the VO was putting, but it was entirely obiter. And the second issue related to something that was termed state error. And ultimately, it was an issue about what the correct effective date was. But it's an ongoing live issue because it's subject to separate litigation. And the UT didn't need to deal with it. The Court of Appeal didn't need to deal with it. It's plainly potentially important, but I'm not going to go and look at it, not least because it's still live. So turning then to the Court of Appeal, the VA decided not to appeal, and an important part of that decision was the fact that there were risks in relation to some of the satellite issues, including those that I just mentioned, and in particular the state error question. But one of the interesting grounds which was considered whether or not to appeal related to the identification of the rooms as hereditaments. Because as I said earlier on, the occupation spilled out beyond the rooms, so that you had the partitioned office and then open plan floor space, and the guardians would put sofas in the open plan floor space, they had gym equipment, all sorts of things. And it was agreed you couldn't draw the red line around their occupation of the open plan floor space, but you could in relation to that irreducible core for their occupation in terms of the partitioned office. And that raises the interesting question of whether or not it's right, where a hereditament is bound up with the concept of occupation, to identify the hereditament by reference to a geographic extent, which is less than the actual occupation. But nonetheless, for the reasons I've outlined, we didn't pursue an appeal. Southwark did. They pursued 4 grounds, the fourth of which was an illegality point. And it was said that the Guardian scheme was illegal because it would amount to an HMO without a license. But at the material day, there are only 4 occupants, and that's insufficient to create an HMO. So that ground was given very little time in both in the hearing and in the judgment. Turning then to the judgment itself, I think it's fair to say that the judgment is not really orientated around the issues as articulated by the appellant. Lord Justice Lewinson gave the leading judgment, and I think he came to his own conclusions on the effect of the contractual position between LHL and VPS and the Guardians, and its effect on rateable occupation. And there are 2 parts of the judgment that pay in particular careful reading. The first is in relation to the legal background at paragraphs 22 to 67. And the second is the judge's analysis, which is paragraphs 70 to 85. A key theme is the importance of the contractual provisions in determining who is in rateable occupation. And the Court of Appeal held that Ludgate House remained in rateable occupation of the Guardian's rooms. It found that Ludgate House had reserved to itself significant rights of control over both the building and the Guardian's occupation of it. And said effectively, where an owner of premises has reserved to itself rights over the premises when determining who is in rateable occupation of that premises, regard ought to be had to the nature and extent of those contractual rights. And the greater the degree of control reserved to the owner, the greater likelihood that the owner would remain in rateable occupation. And he further said that in determining whether the Guardians were in rateable occupation, the upper tribunal had to be satisfied that inter alia they were in possession exclusively for their own particular purpose, but that the upper tribunal had been wrong to have focused solely on the guardian's purpose in occupying their rooms, i.e. somewhere to live, and disregarding the purposes of Ludgate House in having the guardians present, the security. So the key findings, just very briefly, because I'm conscious of the time, the Court of Appeal rejected the upper tribunal's conclusion that the guardians were providing no services to Ludgate House. There may have been no direct contract between Ludgate House and the guardians, but Ludgate House had engaged VPS for the specific purpose of providing guardians, and the guardians were the means of providing that service. They couldn't have performed it without living in the building. So their presence was an essential element of what had been bargained for. Then the Court of Appeal looked at the upper tribunal's conclusion that it was the particular purpose of the possessor that was of importance, i.e. the purpose of the guardians or licensee. And based on that, went on to consider the purpose of the guardians in taking the accommodation without regard to the wider purposes of Ludgate House. And the Court of Appeal said, that would be true of every lodger in a lodging house. It would have also been true from the perspective of any bank which placed an ATM in a retail supermarket. The judge said, in a case like this, the purpose of the guardian on the one hand and VPS and LHL on the other hand were complementary and mutually reinforcing. The purpose of the guardians living there was to facilitate VPS's operation of providing the guardian services. The upper tribunal had said that the terms of the license were not inconsistent with residential use. Well, the Court of Appeal said that wasn't the right question. The question was whether the terms of the license were inconsistent with exclusive occupation by the guardians. And the terms of the license proclaim several times that a guardian is not being granted exclusive occupation of any part of the building. And then it went on to say that Ludgate House hadn't given up possession of any part of the building. Its agreements made that clear. On the contrary, those agreements assert that Ludgate House had retained possession and control and forbade VPS and or guardian, or VPS from occupying and the guardians from exclusive possession. And the purpose for which Ludgate House was occupied was a common one with direct benefit for Ludgate House and or VPS. It was a case in which Ludgate House had retained at least contractual control over the building and to realise that benefit precisely because neither had parted with possession or indeed occupation. And so he said that the question was not so much paramount occupation, but general control. And finally, he went on to say that the upper tribunal had been wrong to focus on the question of whether or not there was evidence from which general control by Ludgate House could be discerned. They were looking for the exercise of rights, but the Court of Appeal said they were wrong to confine themselves to that question. It's clearly relevant, but to confine themselves to that question was wrong. They had to look at what the effects of exercising those rights would have been. So the conclusion was that the effect of the contract was a point of law, and the Court of Appeal said the upper tribunal had misappreciated the effect of it. So I've taken too long. What are the practical consequences? Well, it may well be the end of viable property guardianship schemes. For such schemes to be effective, the owner would have to give up a degree of control that runs the risk of creating an assured short-hold tenancy and negates one of the key benefits of guardianship schemes, namely their flexibility, temporary nature. There is an application for permission to appeal to the Supreme Court. We'll have to see where that goes, whether the Supreme Court has the appetite in the absence of Lord Carnworth, and where they've only just recently looked at not dissimilar issues in Cardtronics. So whether or not permission will be granted is a matter of watching this space. So with that, given the time, I will draw stumps and hand back to Sarah.
Thanks very much, Mark. That was terrific. And we've got a little bit of time for questions. I can see in particular Horatio has been beavering away answering a number of those in connection with liability orders. I wonder if, I don't suppose, I'll just wait for everybody to switch their camera back on. There he is. I was waiting for Cain because I could see that there were a number of questions. Cain, I don't suppose you've seen some of the questions
Yes.
in the Q&A, and I thought I'd come to you first, and perhaps if you could, just for the benefit of everybody, I know people can see the Q&A, but if you just sort of pick up on those points that you want to respond to and tell us what the questions were.
Yeah, well, so Roger has asked if one can argue that the very fact the tenant has performed works makes the heritage less suitable for any other tenant and has therefore narrowed the market. Therefore, the price point at which the hypothetical tenant has to overbid the highest other bid is helpfully reduced. So in effect, is the tenant reducing the value of the heritage by doing works to make it more suitable for its own occupation? And in answer to the question, can you argue that? The answer is definitely yes. However, there's a strong contrary argument that, you know, the hypothetical tenant is really an abstraction designed to secure valuation on an equivalent basis, and that process is distorted if you pay too much attention to exactly how the hypothetical tenant represents demand in the marketplace. So I think ultimately these theoretical arguments are likely to sort of cancel each other out. What that will mean is that there's unlikely to be any addition where the ratepayer does works which any occupier would have had to do in some configuration. So any occupier would have had to put in air conditioning or partitioning to an office, say. I don't think that there will be any reduction to the rent just because the particular tenant did those works in a particular configuration which suited it more than they would have suited other tenants. And that was what happened in my Butterworth's case, and what I think, just to tie in another question, Ronan, what Ronan's envisaging in his question. So I think that sort of sets the scene there. And just to pick up the other question of me, Simon Moore has asked how one should deal with reinstatement costs at the end of the lease, which is a very good question. Arguably, you should take them into account in the adjustment of the rent, because the tenant there, the actual tenant, is agreeing to pay a cost. That is the cost of reinstating the hereditament to its original condition, which the hypothetical tenant in rating doesn't have to pay. The hypothetical tenant simply pays a rent. So arguably, in adjusting the actual rent to reflect rateable value, you should take the cost of those works into account. However, that raises difficult questions about how you then account for the cost and value of the works to put in, whatever the tenant's putting in the first place, because I think very unlikely that a tribunal would ever find a fitted out unit to be less valuable than a unit that wasn't fitted out. So this area can throw up in some ways more questions than you can really pin down with answers or evidence. And the alternative, if it all gets too complicated, is to retreat to the conventional adjustments and sort of say everything's swept up in that. But there's certainly an argument there about reinstatement costs, and if a case of enough where enough was riding on it came up, I think that will be an argument worth running.
Thanks, Cain. As you're speaking, I can see others, Andrew, Richard, popping up with further questions, which shows, I think, just how, I suppose, controversial this area can be and complex, depending on the factual scenario. I wonder if I could throw out to the panel a question raised by Ian Roberts, just more generally, whether people have any sort of general thoughts that they can share about arguments available to challenge rateable values, where there's been the effect of COVID and COVID regulations, where there's an absence of actual rental evidence. I mean, I suppose that's going to be a live question, and I just wondered if anybody wants to make sort of some general observations on that, because I can imagine it affecting a great number of ratepayers. I was told don't point at anyone, which I won't do. But if anybody wants to mull that, they can.
I'll have a shot. I mean, I think that
Thanks, Kate.
the first thing you need to do is work out what material change of circumstance you're relying on, and then that will then. So I think that's the more important question. What is it exactly about COVID situation that you're trying to reflect in the valuation?
Yeah. I think in that regard, there's an interesting discussion and debate to be had about the extent to which the change in circumstances are the coronavirus regulations themselves, and the effect that they have had, if it's as a result of a statutory requirement that a hereditament has effectively been shut down or rendered incapable of use in its normal fashion, then is the MCC the lockdown rules themselves, or is it something else? And as you say, which MCC you fit into, and what is the trigger, what is the material change of circumstance, I think is something that is ripe for debate and litigation, potentially, depending on what the government decide to do about it. I'm trying to see if there are any more. I can see lots of questions. Possibly a question for Gregory. I'm just. I'll give everybody a chance to sort of digest the questions, because they're, as ever with rating seminars, never easy. I think Greg wants to come in.
No, I don't.
Greg.
I don't particularly want to come in, but I just say there is a question for me. So I'm just about, I think it's the relationship with the chip shop. And actually, Cain, you were not acting for the chip shop, but you were acting for the other parties in this case, weren't you? I see. So I don't know whether you got your mind into the relationship between Foundry Mill stores and the chip shop. But in answer to the question, the primarily do go into it in some detail, and there was ownership and common ownership, and there's a father and son, and there was also the fact that although there was separate occupation, it still was a case of that it wasn't it was still exclusive. So they found, looking at in some detail, a range of factors, that it was rateable together. So yeah, it really turns on the facts of the case, and there was quite a close relationship.
I can see we've got a question from Wayne Cox, who refers to the LCC and Erith Parish, the principal in that case. And I've got to take this opportunity, because we're not stuck in our seminar room, but I'm stuck at home, to share with you, and I'm sure many people on this call have this, the much coveted principles of rating calendar of 2021, which was possibly the best Christmas gift any girl could ask for. And I'm not going to embarrass Wayne, but he got me that gift, if one is allowed to receive gifts still at the bar. But I just show you a lovely picture of LCC in Erith Parish and the hereditament it was concerned with on the front of my lovely calendar. But he makes a valuable point, Wayne, or arguably a valid point to Cain's discussion about fit out, that if it's sort of, you know, the idea that if the fit out which has been conducted is of value to the occupier, which presumably it must be, otherwise they wouldn't have conducted it, does that necessarily mean that it's added value in an objective sense? I suppose that goes to the heart of what you were talking about, Cain, but it's an interesting point.
Yeah, and I think that is the sort of counter argument to the point Roger was putting, and I think it probably comes down to how does it add value for the occupier? Is it adding value in a way which would benefit purely that occupier and no one else? So is it sort of, you know, personalized branding or some sort of decoration scheme, or, you know, whatever? Perhaps that occupier has a particular penchant for very thick carpets or something, you know, that is sort of personal to them, or is it just their version of something which any occupier would put in which case I think it's reasonable to view it as increasing the value of the hereditament. But, you know, the number of questions just shows how much dispute and controversy this was.
So your sort of air conditioning example, you know, something that presumably one could argue would be of value to any tenant, you know, as opposed to branding that or a particular layout that may be simply of value, if any, to a particular occupier.
Indeed. I think I'm about to be interrupted. Excuse me.
Right. Well, I can see that we have just hit the 3:30 mark, maybe gone ever so slightly over. I always think that there's some brownie points as chair for finishing on time, and I want to get my brownie points because I was once in the brownies, which leaves me just to thank all of you, especially the hardy 318 of you, minus us a lot, I suppose, who are still here and who've joined us this afternoon. It's been great having you, and we hope that you've enjoyed this discussion. We'll take a look at the chat, and if there are people we can pick up with later, if we didn't get to your question, then we will do so. But we hope you found it useful, and we hope that you'll join us for the next one, and you'll be getting the slides so you can go home and study them if you choose to do so. So thank you, everyone. That's goodbye from me, goodbye from my panel, and goodbye to all of you. Thanks a lot.
Thank you, everyone.